just doing some experimenting on recording today. So,
Oh, good.
Oh, cool.
thank you everybody for being here today on this subcommittee meeting. This is something that we wanted to do so we can specifically talk about a single subject. We know at the commission, we look at the mandate that was given us. Um, we look at when we look at a transformative system, we look at the next three things as being bail reform, reentry, and capacity cap, so population control. So we wanted to take each of them specifically and talk about them and try and narrow down the hugeness of each of those topics and figure out where are we going to be in 6 months when the legislature opens and when they ask us what have we been doing for a year and a half. Now we can discuss all the negative things in terms of how long it took them to pick us and how long it's taking for them to get an oversight coordinator. But I need to, as the chair, I want to move forward and try and get us organized into a working body as we wait for those things to occur in terms of our staff. And I'm thinking that bail may be the easiest first step at this particular point in time, just to have a discussion and try and lead us into a direction where we, as a commission, will begin discussing on what is it that we will begin to share with the legislature come 2021. And as well as to determine the fate of the commission and its works in the near future. We have to understand that the task that's been given to the commission, the Oversight Commission, is going to be a journey, yeah, a long-term journey, and nothing really is going to happen overnight. And as far as, you know, for those that sometimes often refer to me as an agent of change, I'm the first one that's going to tell you it's time. It takes time, you know, and to strategically plan how we move forward in order for change to occur and to get the willing partners to sustain that drive and that passion to create a better system for our people and those affected by the criminal justice system. So if we're going to have a journey on bail, let's start it today. And begin the discussion about it. So I know on our agenda, you see Kamaili gonna make a presentation. Right after that, Judge Ibarra is gonna say a few things, and then I'm gonna ask Mr. Bagasol to give us some insight on what the public defenders witnessed and participated in during the pandemic. We really want to understand why we went to, why the state moved in terms of towards bail reform. What is the situation with bail and why is it a concern to us? And all the things that the Act 179, if you read Act 179, a large amount of that has to do with bail. Yeah, it's somewhat confusing for me, but we want to understand that everything that is said should happen that didn't happen, and then what happened when the pandemic hit and all of a sudden everything worked, yeah, and we were able to release and we were able to maintain a population cap during the time period. So that's kind of where we are right now. Well, sorry, I can't keep Sherry waiting. Let's start with Kamaili. Can you introduce yourself and then give us that presentation I asked you to present?
Yes, let me try to share my screen. Oh, you have to allow me to share my screen. I don't really know how to do that. Do you know how to do that?
Try now.
Okay. Whoop. Oh no, you're sharing your screen.
Okay.
That's a nice screen.
Okay.
Let me see.
You may need to be able to speak while I'm figuring this out.
What you need to do, okay, yeah, you need to stop sharing and then probably go into the settings, like the host settings. if you hover back over Zoom, there should be like a screen and an X, and then or something like that, like the icon that says stop sharing, and then from there you'll be able to figure it out. But anyway, I'll get started on speaking while he figures this out. So aloha everyone, my name is Kamaile Maldonado. I work at the Office of Hawaiian Affairs in the Public Policy Division, and I've been working with criminal justice and criminal justice reform as one of my issue areas that I focus on due to the overrepresentation of Native Hawaiians in the criminal justice system for I think like 7 or 8 years. So relatively new actually on the landscape as far as this group goes. Oh yeah, cool. I can share now. Let me know if you can see pretrial change in Hawaii. Yeah.
Yes.
Okay, great. Sorry, yeah. It's also like I'm like looking at multiple things, so I can't actually see if you guys are giving me indications. But anyways, yeah, so I was around for at least the most recent iteration of our facilities are overcrowded and Native Hawaiians are overrepresented, and what do we do about it? I think that we've probably gone through this cycle in Hawaii, at least from what I could tell from recent presentations that I've also sat in, at least 4 times in the last 40 years. So, so here we are again, but you know, I think maybe a little bit more progress has been made each time, but it's been fairly incremental, I would say so far, at least from what I can see again. But this, you know, this moment that we're in presents a really great opportunity, I think, for really reflecting on like what can be done and what should be done. So, so yeah, I'm gonna give you guys a little bit of a recent memory overview of the most recent actions that have occurred legislatively. And I'm sorry, but there's like 2 flies that have been bothering me all day and they won't leave the room. So you'll just see me kind of doing like this and you'll think I'm just doing my normal talking thing, and it's fine. Okay, so let's begin. So in recent years, I think it probably started in recent memory around like 2014 or 15, that kind of big ideas of prison reform and pretrial reform were coming to the legislature, but they weren't really getting a lot of traction. They would get like a hearing or 2 if they were lucky and then just die. And there wasn't really any kind of big actual change or movement until 2016, when this kind of new idea developed to create a task force, which is not a new idea. This is what the legislature always does when they really don't know what to do about an issue that's been plaguing them for a while. So in any case, they liked the idea of creating a task force, putting together a bunch of experts from across the state to give recommendations to them about how to address the issues of overcrowding, terrible recidivism, and just in general, like a general lack of public trust or belief in the system as it exists today. And so in 2016, they passed HCR 85, and then in 2017, I believe it was 2016, but yeah, and then in 2017, HCR 134. So HCR 85, and also I want to say that this is against the backdrop of kind of a big national movement, a big sweep across the nation of people of other states really thinking critically about their systems, and kind of like in some states overhauling their correction system, and in some states, especially in around 2017 or that time, overhauling the pretrial systems. And so I think maybe that's why there was a little bit more interest in this at that time, because the experiments were already happening in other legislatures and other judiciaries across the nation. So yeah, so in 2016, HCR 85 was passed, and that task force was intended to focus on prison reform, and it issued its final report in 2018, and some of the big kind of broad sweeping key recommendations were, the biggest one is about transforming the correctional system from a punitive to rehabilitative model, and there are a lot of sub recommendations within that as well, reducing Native Hawaiian overrepresentation, really examining and expanding evidence-based programs to improve the rehabilitative quality and also the opportunity that incarcerated individuals have when they get out. Improving the re-entry process and especially developing transitional housing resources and establishing, obviously, the Oversight and Implementation Commission. Originally, as intended, the task force wanted to see an implementation commission that was going to be the enduring kind of long-term plan for how to plan and map out and blueprint and be flexible, but like a permanent entity to oversee the change that the HCR 85 task force envisioned needed to occur and could not occur. There was no way that the kinds of big, broad, sweeping, holistic kind of pre-contact and post-re-entry ideas that were put into the task force report were going to be implemented within that following session with a single, broad sweeping group of legislation. It just wasn't going to happen. And so actually I think as far as I remember, the only thing that remained, I think 3 of the recommendations of the task force went immediately to the legislature that following year, and only 1 was picked up and passed, and that was establishing the Implementation and Oversight Commission. And what the legislature did as it did that, which maybe, maybe some of us don't know, but the original intent was that the Implementation Commission would be in charge of implementing, assisting PSD in coordinating a transition from a punitive model to a rehabilitative model, constantly reviewing, examining all of the different recommendations of the task force, and really trying to map out a 5-year plan, a 10-year plan. How do we see the transformation at the end of the day, and how do we get there? And so that was the intent, and also to investigate complaints against public safety and to provide oversight, which is community or public oversight over public safety is something that's done like pretty regularly in many, many, many other jurisdictions and has been fought for a long time here. So that was considered a really big win. But additionally, the legislature added 2 other commissions worth of responsibility to that commission in this legislation. And then through some kind of like legislative theatrics that occurred throughout that session, there were a lot of, the legislation was actually introduced, like I said, the final report was issued in 2018. The legislation was introduced in 2019. So we're talking about the session of 2019. At that time, the HCR 134 task force, which was established a year later, and had a much narrower focus of just looking at reforming the pretrial system with a specific charge to look at how to reform the system with the intent of or the goal of reducing the overall incarcerated population that was unnecessarily incarcerated pretrial. Again, these are accused people. They are legally innocent people. There's really not a reason why we should be paying hundreds of millions of dollars a year and overcrowding our facilities to the danger and detriment of the community as well as the system itself, when we can potentially safely release a lot of these people, harm them less, and save a lot of money. And so that report also came out in 2018, December of 2018. And so the legislative recommendations were being considered also in the 2019 session. So there were a lot of different bills that were introduced to implement the recommendations of the HCR 134 task force. And all of them, through one way or another, eventually died. And as a Hail Mary at the last minute during conference, the compromise group of ideas that were pulled from all the different bills it wasn't a gut and replace, it was just like they were gutted into the HCR 85 Oversight Commission bill. So originally that bill was just the Oversight and Implementation Commission, and all of this got added right at the end. So nevertheless, they, it's not necessarily like they're related, they just happen to fit under the same title. So the key recommendations of the HCR 134 task force on pretrial reform were generally, they wanted to see different kinds of small and incremental changes that would create fairer bail determinations, that would consider more comprehensive bail information, and setting bail based on a defendant's ability to pay, because what we saw, oh, by the way, I helped with the HCR 85 task force, and I was on the HCR 134 task force along with a few other people who are here in the room. But so what we saw when we examined the system was that bail was just being set, and there was actually no point at which defendants' financial information was being shared with the court. So there was actually no way that the court could be basing their determinations of bail on whether somebody is able to pay, which is actually constitutionally required. And so they kind of made a little adjustments to that to try to make it a little bit fairer in that way. And then also making the pretrial system more efficient, requiring faster bail reports, prompt bail hearings, encouraging fewer conditions on pretrial release, like supervised release. Sometimes you can apply, or the judge can apply a myriad of different conditions. And essentially, I'll talk a little bit more about this later, but Judge Trader encouraged or drafted language to encourage judges to really think about reducing those conditions on pretrial release, and then also expanding the availability or the ability and accessibility to pay bail at whenever is necessary for or convenient for people, so that people can get out as soon as possible. And then lastly, collecting better data and developing stronger policies. So both of the task forces kind of had this same idea of investing in a permanent entity and vesting a lot of its kind of trust and its intent for how all of this would be applied in the future within those entities. And so for the HCR 134 task force, that was in the form of the statewide criminal pretrial justice data system and the Criminal Justice Research Institute, which I'll talk more about a little bit later. But essentially, what the HCR 134 task force wanted to see was better data collection on the entirety of the pretrial process, being able to connect all the dots to really see what is happening and why, and having that entity constantly keeping up to date on national trends, things that are going on in other jurisdictions, what worked, what didn't, and making recommendations to the legislature, recognizing that this process is going to be iterative. It's not going to be a one-time fix. Like, we didn't pass 179 and now our bail is reformed. We have to constantly engage with these things. And I think the task force kind of also recognized that whatever we know today is a really incomplete picture of what's actually happening, because the data is incomplete, and also because because we didn't have a lot of time. So it was a very truncated process. So in the HCR 134, which is the pretrial task force, which I'm going to be spending most of my time talking about the recommendations that came from that task force and how they got applied in Act 179. So in general, like I said, it was kind of in response to this national bail reform movement. We had states like California and New Jersey, and just a kind of across the board, people or other states, other legislatures, other judiciaries really taking a much more scrutinizing look at their bail systems and completely overhauling them. And so this measure, HCR 134, was led by the Chief Justice and the judiciary. And this was immediately after their 2016 Forum on Criminal Justice Practices. They got a lot of good information about what was going on in other jurisdictions, as well as a lot of data. And I would say it was kind of quantitative, because they just had a lot of judges come to the forum and talk about all of the issues with the pretrial process and how inefficient everyone felt that it was, and how they felt like there were a lot of people just getting caught up in the system and stuck there and not able to get out of it, and just feeling a little bit constrained by the system and not really knowing what to do about it. So that's why the judiciary really spearheaded this effort to develop this task force and to make recommendations about changing that system after a more thorough examination. At the time of passage, I read through Kat Brady's testimony, and she reminded me that over 50% of the OCCC population at that time was pre-trial, so 540-ish out of 1,100-ish at the time. And just like a reminder, I think the OCCC what do you call it? The population limit is around like 900, I think 925, something like that. So overcrowded, and over half of people are actually pre-trial. They're just being held because for whatever reason, we can't trust them to show up at trial, or that's the theory. And I just wanted to add a couple of reflections about the task force before we jump into the actual recommendations, just based on like the temperature of the room. I felt like Chair Ram Trader is a judge in the first district, I think, and now he's in the federal Hawaii district, but he shared a lot with us very early on, and honestly throughout. I think he was a very strong and diligent leader, but he also seemed very genuinely inspired by the charge that we were given, and he also seemed genuinely I don't want to use the term remorseful, but scrutinizing of his former practices and his former thoughts on the subject. And so he encouraged everybody in the room to kind of really examine like the impacts and the effects of what it is that we're doing, and whether or not it really makes sense and it really achieves the ends and the goals that we're looking for in like improving public safety. I would say that everybody else in the room seemed generally interested in the system's change. But I wouldn't say that everyone in the room was very committed to it. There were a handful of people who really wanted to see the whole system change. And there were people who were just like, this sounds interesting and I'm willing to entertain it. The neighbor islands had a lot of distinct issues that came up throughout the process. And I think in general, the resulting report as well as the resulting law tends to be a little bit Oahu centric. Like all the rest of the state laws, I think, tend to be a little bit Oahu centric. Like they're kind of formed around Oahu's unique population and needs, but not necessarily like really well tailored to what goes on the neighbor islands. There was a vocal minority of people within the group that proposed a no cash bail option via the concept of unsecured bail. And that's something that I'll also talk about a little bit later, but it was an idea. It was kind of a compromise idea, to be sure, from the start. And it also did not pass, although I got a significant enough of a percentage of the vote that the task force decided to put it into their report as the minority report on that specific issue. And then lastly, I think this is just a personal reflection or opinion, but I felt that the membership was a little bit imbalanced, and that there were a lot of prosecutors in the room, there were a lot of police in the room, there were a lot of criminal judges in the room, of course, from every district, every circuit, and the same for the prosecutors and the police departments. And then there was a defense attorney from every circuit, and then one representative from the public defender, and then there was like OHA and a public member, and then a whole bunch of like judiciary people. And so I did kind of feel like in general, the conversations had a slant. And in general, ideas of kind of radical progressive thinking about bail, about pretrial process, about pretrial detention were just generally not going to be entertained in that particular space. And so that was unfortunate, but it is what it is. The report recommendations are compromises. And so it's really important to recognize that, that is kind of the legislative process. It is what it is. And even all of the recommendations that were put into our report were not actually, were further watered down and compromised to the end of the passage of Act 179. So it's just like important to realize that everybody wants to look at it as we put all these experts in the room and these are the best possible like recommendations that they could come up with. And it's like, these are the lowest common denominator that everyone was willing to agree to. Some people feeling like they were under duress in doing so. Hold on one moment. I need to open my window a little bit so I can get some more light before the sun goes down. Okay, here we go. So let's dive in to some of the things about Act 179. Like I said, HB 1552 was originally the HCR 85 task force measure. It got changed or added to at the very end in conference to add all of the pretrial stuff. And here we go into the pretrial stuff. So I'm just gonna block it out into kind of like areas of the pretrial process that the measure speaks to, and it has a lot of different changes for each part of the process. And the bill also parts these out like this. So I think intake service centers is in part 3, I want to say, and then it goes down. So every like different grouping that I'm going to do goes part 4, 5, 6, if you ever want to find any of this in the actual measure. Oops, sorry. Okay, here we go. So yeah, with regard to the intake service centers, all that the task force really wanted to see was that everything gets tighter and more efficient. So they wanted to, at that time, bail reports were taking weeks, especially in like felony cases or higher level offense cases. They were taking a very long time. And so people were being held at least for that period of time without even being able to ask for a reconsideration of their bail, because the judiciary wanted to see the bail report. They wanted to see the pretrial risk assessment, et cetera. And then formerly, there was no report on financial circumstances. So like I said, the judiciary couldn't even consider whether somebody, you know, who was telling them, I can't afford this bail amount, like whether that was actually true. And as well, there was no evaluation of risk of violence before. And that was something that the task force wanted to see changed. And so that was a recommendation, and that was in the original measure. Oh, and sorry, that was actually what passed. I start a couple of items throughout this thing just to flag for the commission, because these are things that I'm not exactly sure how they ended up getting implemented, because I do remember that there was a bit of confusion or maybe like unsurety about how to implement that, because the particular pretrial risk assessment that they used at that time did not evaluate risk of violence. And so I don't know if they have procured a new risk assessment or a combined risk assessment tool. So that might be something to look into if you're interested in that particular piece of it. Although I would say that I focused a lot on pretrial risk assessments during this time. I learned a lot about them and their impact on this process. So yeah, it's worth looking into, and I'm happy to talk about that more. Including the fully executed pretrial risk assessment. This is just all about accountability and transparency. And then periodically reviewing that pretrial risk assessment tool. So we were finding that it hadn't been revalidated since the original time that it was procured, the ORSPAT. And so, you know, the task force really wanted to see that we're constantly reviewing the tool itself, validating it to make sure that it actually tells us what it says it tells us about Hawaii's population specifically, and determining that all of the kinds of administrative procedures that we use when we're implementing the pretrial risk assessment are still fair, are still effective, and publicly reporting those findings. It was really important to me, at least, that those findings be public so that the public can engage with whether the pretrial risk assessment tool is the appropriate tool at any given time. One more thing, so yeah, that's another thing that I starred, because I'm not sure if there's been any follow-up on revalidating the tool or reviewing the tool and its procedures for effectiveness, and if there's been any public reporting on those findings. And the last thing I wanted to star is that there was something in here that just caught my eye as we're talking about building data, a data body in the future, and maybe, you know, just looking more deeply, examining the whole process, is that the ISCs can provide bail reports to research entities. However, they must be approved and contracted by the Department of Public Safety. And so this was something that PSD advocated to be added in at the legislative, like during the legislative process, because they said that they wanted to protect the confidentiality of the information. And I just don't know if this is gonna prohibit that particular set of documents from being a part of any data collection or exploration that this entity does. Just something to flag for maybe the AG to look into and give you guys advice on. Okay, the next group of recommendations is related to bail hearings. So previously there was no like bail hearing. There were hearings and you could ask about bail at those hearings. But this was just trying to be more deliberate about, we want to make sure that every person has the opportunity to be heard on their bail, and that the hearing should be prompt. They should not be taking weeks and weeks at a time where the person has to remain detained until such a time that they can actually be heard on whether they should be detained for that whole time. And so requiring prompt bail hearings, it was debated a lot about what equals prompt. And I think at the legislative level, it was decided or whatever, agreed to that arraignment or as soon as possible is going to be what it is. And that's when the bail hearings have to happen. And if you have your bail report in hand by 3 days afterward, you should be able to have a bail hearing at arraignment. At least that was the theory, although Willie will be sharing some information about how this works and in practice and whether or not it actually is working as it was intended to. And then as well, requiring release under the least restrictive conditions required. So like, this is something that this language, least restrictive conditions required to ensure appearance and protect the public, is something that got put in throughout the measure and throughout the statute related to bail determinations and all pretrial process. So this is what I mean when I was saying that Judge Trader was really trying to propose language that would encourage every judge to really think about what is the least restrictive kind of condition. And that means bail, cash bail. That also means any other kinds of conditions, house confinement or checking in with an officer or there's so many different kinds of conditions that they can apply. And you really want to think, what are the least restrictive ones to ensure that this person is going to appear? Because that's all we really need to do. Make sure that they show up, make sure that the public is safe. And if you can do that with less conditions, you really should, so that you're not setting people up for failure. Another thing is requiring money bail to be set in reasonable amounts based on the defendant's financial circumstances and based on all available information. So that's another reason why the bail reports were a big focus, because they wanted to see more comprehensive information, especially information about a defendant's financial circumstances, so that they really could tell at the bail hearing time whether the amount was reasonable based on this defendant's income or lack thereof, housing situation or lack thereof. Like, is it reasonable to charge somebody a $5,000 bail amount, or is that precluding them from being able to access the freedom that is supposedly granted by that bail? And then lastly, would be establishing a statewide program to permit the posting of bail 24/7. So it was a big issue that people couldn't post bail like when they were able to, when they needed to, and they were ending up having to stay detained for a longer period of time because of that. So I'm not really sure if that's a big sticking point, but I don't know whether that's actually been implemented. And then for the community correctional centers, there's two main things, which are one, periodic review and survey of the jail population to consider whether anybody in there is appropriate for pretrial release. And so that's a big one that I think is probably going to come a little bit front and center as we talk about how we could restructure the process moving forward, because one, it's already required. As of right now, this was passed in 1 year ago, so there should have been 4 public safety reviews of the entire jail population to determine whether anybody should be released who's currently just sitting inside and waiting for a trial. So that's one thing. And I think it kind of closely aligns to what actually happened during this COVID time, or, at least from an outsider's perspective, that's kind of like what it looked like occurred a little bit. And so that might be a model for how it could be done in the future, especially since, like I said, it's already required. This part about who is appropriate for pretrial release or supervision might need to be teased out a little bit more. They might need a little bit more guidance, maybe a little bit more coverage for how they're going to be providing this list or review. And they're supposed to be providing that to the courts, who will consider modifying the bail order, which is essentially what happened during COVID. So yeah, so that's an option. I mean, it's not really an option. It's required under the current law. And lastly, in the judiciary, so there were 2 main entities that were established in the judiciary, which I mentioned before. One is the Criminal Justice Research Institute. So this would be a permanently funded research institute that would examine the criminal justice system on a continuing basis forever. And so they already received a $315,000 appropriation in this legislation. And again, it would be for maybe people who have a closer relationship with the judiciary to follow up on that, because I haven't really done any follow-up on where they're at with this. But this could be a really huge like resource for the community and for the commission, because they're supposed to be collecting data across the board over the functioning of the entire criminal justice system, from arrest to reentry, and they're supposed to be monitoring evidence-based practices across the nation and making cost-benefit comparisons and looking at national trends and trying to really think about how trends that are happening nationally might apply in Hawaii. And they're supposed to be issuing public reports annually with legislative recommendations. So I think that if that institute is forming or up and running, it at least has resources and it has a charge to do the exact work that we're kind of talking about right now. And especially because of the statewide pretrial data system. So one of the charges of that new research institute is to develop and maintain a pretrial data system, specifically pretrial data system, which they're supposed to look at all of the different databases that currently hold the information that's relevant to the pretrial system, which are held by public safety, the judiciary, the AG, the police of the various counties. That information is being held all over the place, and there is nothing really that's kind of stringing it together so that anybody who wanted to look at it could see kind of an overview of the whole picture of what's happening. And if, and as moving parts are moving, how things are affecting each other, because those are being held at very diffuse locations. And so they're supposed to be developing a plan to aggregate that information, to share data between agencies, and to develop additional collection of data to fill in any gaps that they find. And they're supposed to be examining everything under the sun related to pretrial, from arrest to bail amounts to to release determinations, to whether the risk assessment score lines up with release determinations, to whether the risk assessment score lines up with whether people actually failed to appear or people actually reoffended while they were out on pretrial release. And so there's so many different things that the system is supposed to do, which I think would be very helpful and very useful information as we're talking about revisiting the idea of reforming the system now. And so that is definitely something that I would recommend that the commission look into. And the other thing that the pretrial data system, like I said, there's a set number of performance indicators that they're supposed to develop, which are like all of these: percent of defendants who appear, percent of defendants whose supervision level corresponds with their risk of pretrial misconduct according to the pretrial risk assessment, et cetera, percent of defendants who remain arrest-free. And so, yeah, like I said, all of this information is so critical to even knowing where to start and knowing where to go with the pretrial system. It's information that we did not have at the time that we did the HCR 134 task force, that we tried to pull from every different agency and entity that had it, and kind of like analyze and synthesize it in a very short time, and also make legislative recommendations based on personal qualitative contributions. And it was extremely challenging. And this was kind of the response. This was the result. Like, if we can just get somebody else to give better data and information to people who are thinking about this in the future, they will be able to make better recommendations than we were able to make. And that's what we really wanted to see. And so lastly, I want to talk a little bit about a few of the recommendations of the HCR 134 task force that were not implemented in the final Act 179 law, which one of them was, and this was a huge one, this was a big matter of contention. Even the way that it's drafted now is a big compromise for the people who were in the room, but eventually the prosecutors were successful in having it cut out of the final bill or the final law as it was passed. And so the first one is elimination of use of money bail for low-level nonviolent offenses. So low-level meaning traffic offenses up to misdemeanors, and nonviolent meaning anything not involving, and then it has a list of violent offenses like assault and family violence, and DUIs, etc. So in those cases, everybody should be released on their own recognizance, except if there's kind of a set of, I think, 6 or 7 exceptions. Except if any of these exceptions apply, then money bail can be set. But if the defendant cannot afford money bail, then they're entitled to a prompt bail hearing just like everybody else. They can argue their case about that they can't, that they can't afford it and it should be reset to a different amount or discharged entirely. And if the bail is less than $99 and the defendant is unable to post it, then the director can just release the defendant using electronic monitoring. So that was like a big kind of like everybody who fits in this ROR, unless these narrow set of exceptions apply. Then you can apply money bail. Then you can, think about whether it's appropriate. Then the director can release if it's really, really low. And then the other one that was huge is the rebuttable presumptions regarding release and detention. So this provision would have created a rebuttable presumption that any defendants for any offense that are not a serious crime, so serious crimes are felonies A and B and crimes of violence. And so anybody who doesn't fall into that category, which pretty much is felony C, nonviolent, and everybody else, all the lower level crimes. So anybody who fits into that should be released or offered bail under the least restrictive conditions, unless the prosecution can show by clear and convincing evidence that there is a specific and serious risk of non-appearance, of obstruction of justice or witness tampering, danger to the public or to somebody else or to themselves, or that they're going to reoffend, that they're going to get out and go right back to crime. The prosecutor would have to show that by clear and convincing evidence, which is a huge barrier. I mean, a huge burden, a huge hurdle to jump. And also, I mean, there was a little bit of like, it also creates a rebuttable presumption that this risk exists if this person has a criminal history or a history of non-appearance or a history of crimes of violence, etc. But that, again, it was all compromises. If the serious risk is shown, then this person can be detained if no condition or combination of conditions will reasonably eliminate or mitigate that specific risk. So this was confusing, so I made a chart. I don't even know if the chart makes more sense, but I made it. All these charts are bad. I'll just say that. I'm not a chart maker, but I spent a lot of time last night, like way late into the evening, making charts that at the end of the day don't make any sense. But let's just like try and understand it. So in the beginning, all non-serious defendants should be released on ROR, least restrictive conditions. But if the prosecutor can demonstrate a serious risk of non-appearance, reoffense, or violence, then the risk has been shown, then they can either go to bail or supervised release, depending on which combination of conditions could mitigate that specific risk of non-appearance, reoffense, or violence. If no combination of conditions could mitigate that risk, then detention is the answer. And I think that although it's a little bit confusing the way that it's worded, it actually presented a really strong option because it essentially made release the norm or the kind of the default. And you only detain people or even apply conditions when you can show that there is a serious risk that this person is not going to appear, is going to reoffend, or is going to be violent. And then you tailor the conditions to manage that risk specifically. It's not like a broad, like everybody gets cash bail and everybody can potentially be eligible for supervised release under all these conditions. It's really tailored and based on an individualized assessment of what is going to make this person show up, incentivize this person to show up and not commit further crimes. That is actually the purpose of the pretrial and bail systems. And so I thought that this was a really good option, and it took a long time for everybody to agree on. And at the end of the day, the legislature could not agree on it. So it ended up getting removed. So that is still something that is up for discussion. And lastly, reinforcing law enforcement's discretion to issue citations instead of arresting. That was something that law enforcement was not in support of, and the task force moved forward with it anyway. And at the end of the day, it got removed, which I'm not very surprised about. I wanted to add one more, which is unsecured bail, Act 277, SB 192. So like I said, there was a group of vocal minority within the HCR 134 task force that wanted to see a no cash bail option. In fact, we were not the ones who wanted to see it. The community came and testified at the very first 2 meetings of the task force and said, we want to see a no cash bail option. And then we proceeded for a year talking about all the different ways we could tinker with the system to make it more efficient, more fair, like make sure that we're considering every possible thing and all the information is available. And now we're going to collect data and everything. But at the very end, like right before we were about to vote, our public member raised his hand and said, you know, the community came here and asked us to develop a no cash bail alternative. And I don't see any options on the table for that. So Judge Trader, being the judge that he is, said, bring an option and we'll vote on it. So we met feverishly for a week and we developed an option, which was this. I took it home after it failed at the task force level and I honed it a little bit more and I made it a little bit more of a compromise and a little bit more palatable to those who would oppose it. And it's basically modeled after the federal Hawaii district, which does 98% of its releases with no cash and has a 0% failure to appear rating. And I thought that that would be a good model that people would really like jump on board with that. But essentially it's kind of like creating like a private bond kind of idea where if the defendant can't afford bail or it will cause a financial hardship. So like even if they have the money to afford the bail, but it means that they can't pay their rent or buy food, then they should petition for an unsecured bond, and that the financial bond will not be executed unless and until that person actually fails to appear or actually violates the conditions of their release. I thought it would be a good option for judges, but I think at the end of the day, it was a little bit too cumbersome for the judiciary to manage, a little bit too confusing. So it's, although it has passed into law at the same time as the rest of these measures, it's not currently in use as far as I know. So the last thing that I want to present, and I'm sorry that I've gone on for so long, but I just wanted to, I was looking at the numbers, the public safety population numbers over the past several months, and it was confusing to me because I couldn't really tell what I was looking at. And even now that I've made charts, again, I learned how to make charts last night. So like, I don't even know if these make sense, but I'm hoping that maybe some of the academics in the room look at these and see something more than what I can see and maybe have an idea of where we might want to go first, because again, without good data and pointing us in the right direction, we're really not going to be able to evaluate any of the options that come to our table or whether any of them have worked. And so this is just from February of this year because it's right before COVID. So it kind of captures the moment right before COVID happened and then the progress through our COVID releases and then what's been happening since then. So you can see that these are the numbers by facility. So Oahu is up here in yellow, Hawaii Island is in dark red, Maui's in pink, and Kauai's in purple at the bottom. And so you can kind of see that they all kind of follow this same path where everybody kind of drops down from February to April to differing degrees based on their proportions, and then have all been climbing back up slowly since that time. So we all reached a low point and now we're coming back up. And then I also wanted to kind of look at the population change by facility. So in each of these charts, you can see that the yellow line on top is the overall population at that facility. The green line on bottom is the pretrial population at that facility. The red line on top is the operational capacity, and the blue line is the design capacity. So in this, I guess like what I got from it, looking at it visually this way, was that the pretrial population more or less tracked the progress of the total population at each facility, in that they came down together, they started going back up together for the most part across the board. And you can kind of see that the lines get closer together and further apart, which shows that the pretrial population is a greater proportion and a lesser proportion of the population, which means that for those periods of time, really something was happening with the other people who were not in the pretrial group. But what was interesting to me, I mean, at least as we're talking about population limits and talking about getting down under a certain amount, is that only one facility really got underneath its design capacity, which was the goal capacity, right, throughout this process. And that was Kauai. It went down below them, but now again, it's nearly back up to what it was when we started. Hawaii Island never got below either of its capacities. Maui and OCCC both got below their operational capacity, but they did not dip below their design capacity at any point during this process. So that was just interesting to me. And then one last thing that I wanted to look at was the proportion of the total population at each facility that was pre-trial. So like, meaning if we were seeing a big drop in people, are those people pre-trial? Like, what was that the place where we made the biggest dent in the population density, or was it somewhere else, anywhere else? And also because when I read Kat's testimony and she said, we are at 50% of our extremely overcrowded population is pre-trial. They're being held because they are waiting for a trial. Sometimes weeks, sometimes years. We're holding people waiting for trial. And that really like reminded me that that's where we're at. And I was like, wow, 50%. I wonder if that's changed. And so I looked at it and again, kind of hard to see, but here's Oahu over here in yellow. And you can see that we were at about 50% when we started this, and we did dip below a little bit, but now we have climbed back up. And now that what this means is that now the pretrial population is a greater proportion of OCCC's overall population than it was when we started, and than it was 2 years ago when we were first talking about pretrial reform. And that was a big impetus for pretrial reform, is that such a great proportion of our population is pretrial. That doesn't make any sense. And now we see that after all of this, even more of our population is pretrial. And you can kind of see that for the most part, except for, with the exception of Maui, for the most part across the board. Maui kind of went up and down, and then it ended up right where it started at around 50. But like I said, Oahu is at 58 now, or 59, somewhere around there. So we're much closer to 60% of OCCC's population is pretrial now. And then Hawaii County, just, I don't know what happened here, but they were quite low at the beginning of this, and now they're much higher, reaching a high point at 54, and actually ending up last month close to about where everybody else is with their pretrial populations in proportion to everybody else in the facility. So so that's all I have for my presentation. And again, sorry for taking so long, but yeah, I want to turn it back over. Oh, can I say one more thing? This is just like, again, another disclaimer, is that like, I don't actually know what any of these tell us. These are for smarter people who are good at statistics than I am. I just wanted to see it visually, and I was hoping that something would come out in this that would help us at least know where to take the first steps. But yeah, again, that is for other people to hopefully dig more down into and decide. Okay, thank you.
Thank you so much, Kamaili. That was very informative. I know there's a lot of people here appreciative of understanding the historic walk to get us to where we are today. A lot of information and a lot of questions, if not more than information that you gave. And it kind of cleared me up a bit, a lot actually, where maybe Bill wasn't the easiest of the mandates. So let's look at Judge Ibarra. Can you give us some comments on you know, there's a everything that Kamaili just said about that, what I call the intake system, or the bail portion, the arrest, the bail, the arraignment. There's a human factor in there, and Judge Ibarra always talks about the factor of, you know, the individual judges, the individual prosecutors, the individual public defenders, and what is the gatekeeper's mindset when they have these people in front of them and what they're trying to accomplish, whether they're going to give them bail or they're going to let them or put them into confinement. So I've asked Judge Ibarra to speak a little bit about that based on his experiences. Judge?
Okay, thank you. By way of background, I've been a circuit court judge for 28 years before I retired 3 years ago. I was the chief judge of the Third Circuit, or admin judge, for 24 of those 28 years. And before that, I was a prosecutor for 6 years and defense counsel for 1 year. I also handled the civil docket. But in order to address bail, bail reform or bail implementation, it comes down to this. In any law, to implement any law, is basically the person or persons that are going to implement the law, the attitude, the mindset. And that's why I've always pushed for education of the judges or prosecutors or police, public defenders, and making sure that the law is known and they're following the law. So with this Act 179, the commission was charged with overseeing the population in prison. And we all know that the prison population consists of pre-trial and post-trial convictions, right? And so today we're talking about pre-trial and how the pre-trial folks end up in jail. When I talk about prison, I usually talk about, you're there for more than a year. The jail, I guess, it's the pre-trial where they're holding these pre-trial detainees. But before we can even go into that, let me just share with you what I consider the players that set the bail in the pre-trial system. So it begins with the arrest. If there's no arrest, there's no bail. Right? So it begins with the police arresting somebody. And the arrest is either based on view, where the police, by investigation or receiving information, a person has committed a crime with probable cause. And police can go and arrest the person, take him to the police station, call the prosecutor, or may not call the prosecutor for the appropriate charge. If it's a misdemeanor, well, if the jail time maximum is 2 years or less, the chief of police then sets the bail and gives that person a court date if the person posts the bail. So one bail setting at that stage, chief of police. The other arrest, not from on view, it may be from grand jury indictments or arrest warrants. And these arrest warrants, the bail is already set by the judge because it's an arrest warrant and the bail is set. So when the police arrest the defendant, the bail is already set. And when a bail is set, whether it's by police chief, the bail can be posted at the police station, at least in the Third Circuit. Before this Act 179, my understanding was Oahu and other circuits weren't allowing bail to be posted after hours, which resulted in the arrestee waiting until the court opens the next business day. If it's a holiday, it's a long weekend, the defendant, because there's no bail set, remains in jail until the first court appearance. So Act 179 addressed that. And we did it before that in the Third Circuit. I had the police collect the bail and transmit it to the courts on the next working day. So we're talking about the arrest. So once the person arrested, that person can post a bail at the police station. If that person cannot post a bail at the police station, that person is brought to court. Now, before court, within 3 days, according to Act 179 was brought out, the ISC, usually they go down to the jail before the jail day, and they meet with the defendant and to get information, and they will do a bail report, a bail study, which bail would be the factors that they must consider are all in Act 179, such as permanent resident, prior criminal record, any mental or health issues, and now they have the financial status, job, and things like that. So the ISC social worker at the time of the arraignment would give the judge and the prosecutor and the defense attorney their bail study. So the judge then looks at the bail study. Now, going back to before court, I, as chief judge, issued a bail guideline because there's certain arrestees do not have bail set yet and they're in the police station. For example, if I talked about the on view. Now, if it's a felony, the chief of police cannot set the bail. So somebody has to set the bail before coming to court. If not, the defendant is going to be waiting until the first court appearance. And Act 179, now allows for that posting of the bail. But the question is, during that time, pre-court hearing, who decides for felony cases how much the bail is? So what I did, and I'm sure the other circuits have this, as I call bail guidelines. And for felonies, and this was a big rub, because Third Circuit was the lowest, First Circuit was the highest. For class of felonies, whether it's A, B, C, we started at $2,000. So, the police has their bail guideline. If you're arrested on the weekend, you want to get loose, the police say you commit theft in the first degree, Class C felony, bail is $2,000, you can post it, and we give you a court date to appear. So the bail is set by that guideline so that it's pre-court appearance, so the defendant can go home or can work the following week. Now, if when the person comes to court, the bail that is set by the guideline may be changed because now the court has the pre-trial bail order, bail study. So once it goes to court, the prosecutor makes its argument. Well, judge, we're going to increase the bail. Defense makes his argument or her argument. No, judge, OR, own recognizance, supervised release with least restrictive conditions. Person's working as family, stable residence, and all the factors that the judge may consider. But the bottom line, like everything else, like you point out, Mark, is in the judge's mind. Right? We can have the best laws, as you know, interpretation is where people may differ. And so, that's why we have all this. So why is this person being released? Or why is this person being locked up? They have same crime, they have similar background, but this judge did this, the next judge did that. Again, it's really, we have to educate the person that implements the law so everybody is on the same page at least. I always said, look, Mark, if you and I are talking about bail release, and if you and I at least on the same page of what law to look at or what factors consider, at least that's half the battle. If you going on a different page, and I'm going on a different page, well, we're not talking about the same thing. And so at least, we need to educate the judges, the final decision maker on bail. And so the good part is the ISC. The ISC then, under the new law, has to review after 3 months, if the person is in custody, to review the status of that person again to determine whether that person can come out on bail conditions versus, if a person can't post a bail, because we know sometimes, $1,000 to one person, maybe $100, to another, a richer person, so to speak. So 3 months later after incarceration, the ISC has to review, and it said shall in the statute. So this is where you can check as commission, we can ask the ISC first, how many people have been, did not make bail, and how many people are being reviewed after 3 months, and even break it down further, what kind of crimes, because part of the bail recommendation is the seriousness of the crime. So my take is basically, we got to get first the judges, right? The final decision maker. We got to get the prosecutor. We got to get the public defender. We got to get the police. Now, the bottom line is this, and I even look upon my experience as a prosecutor, as a judge. When we first come on board, basically we're brand new. We're learning about the job. More often, I say more, but there's exceptions. We follow what is the standard here? I want the black and white thing, but we know life is not like that. So as you go through life, you get more experience. You can say, well, I can interpret it this way because from my experience. And so what I'm trying to say is, we need to educate, whether it's the police or the prosecutor or the public defender or the judges, to those that do not have experience yet, to develop I call a bail philosophy, to be consistent, rather than go over all over the page versus, well, I see this a full courthouse today. I see the newspaper or the reporters in there, and I don't want to get whacked because although this person fits the criteria, this high visibility, high publicity case, I'm going to lock them up. Frankly, that's not the way to go. I don't say the judges are doing it, but I can see, pressure, because I've sat as a judge when my courtroom was filled, whether it's criminal case or civil case, and it's great. I look at it and say, well, good, there's a lot of interest, of public interest in this case, so I'm going to decide, make the decision, explaining my decision, and educate the public at that time. Not thinking, whoa, I'm going to take the safe route and be the populist judge. I wonder what these people want to hear me do, and I'm going to follow it. So we got to do education in the judges, and we have to follow up with the Hawaii Intake Service. Frankly, I looked at this, and it's really come down to Hawaii Intake Service Center. They make the recommendations to the judge, all the factors that they must consider, the 3 months review. But interestingly, the 3 months review, I looked at the law. It said they shall conduct a review, and then it says if there is a motion. So what happens? And I'm going to find it in the law there. What happens if there's no motion made by the public defender or a prosecutor? Maybe the court, it doesn't say, but I always did it. The court probably has inherent authority to say, look, I look at this report now, I'm going to schedule a hearing on my own. And you got notice, prosecutor, you got notice defense, we're going to have this hearing on whether this person's bail status should be reconsidered. So the bottom line is basically, we can have all the law and things like that, but if people that implement the laws, the standards, really are all different pages there, they don't have the, I won't say, they don't follow the law, or they don't have the philosophy that the law intends them to have, it's not going to happen. I'll tell, when I was in the Third Circuit, Chief Judge, I used to have meetings every 3 months with public safety. And I always used to ask, this is way back then, and we had our pretrial population down to like 40% of the total population, although there are a lot of people still incarcerated in the HCCC. And I always used to ask the warden, okay, warden, and all the judges were listening. Warden, what's our pretrial population, those that are not convicted? I'm not talking about people that are picked up on probation violation. I'm talking about those that are not yet convicted, the innocent folks, And so I would tell the judge, you heard it, and keep in mind they're not convicted. I never told the judges how to rule because they have judicial independence. It's unethical for another judge to tell, well, you should rule this way and that way. And but it all came down to education, and I think from over 50%, we got it down to 40%. And so when I heard the stats about the Third Circuit, it was kind of low. And now, I'm thinking, wow, it went up. It went up, and there may be different factors. Could be there's a lot of serious crimes that are now pretrial release eligible, and it could be for whatever reasons. But we need more data, like the speaker ahead of Ms. Maldonado has said. Basically, so we know what's going on. But after having gotten the data, then we can hopefully, again, first start with the judges, educate the judges, at least on the law, because judges don't like to be told what to do, and what the factors and what should be the goal of Act 179. That's it.
Thank you, Judge Ibarra. That was very informative as well. I think that was a good flow with what everything Kamaili said, and giving us the example of your experiences. Truly, there is that human element that has the potential to control, if educated, the intake of these offenders going into our system. Let's kind of segue to Mr. Bago. So, Pop, are you on?
Yes, I'm on. Can you hear me?
Yes, go ahead, William. Thank you.
Okay, I'll try not to be long, but I just a little bit of background. Some of you already know me, but I've been a public defender for, hard to believe, 33 years now, pretty soon. And I don't know why James picked me to do that. James, my boss, made me do this particular presentation because there's certainly other people like Jackie Esser, I think she's on, that may have done, may have been just as good, but perhaps maybe he chose me because I was also part of the task force that Kamaili was on too. So I could speak to that maybe a little bit later in the presentation. But really quickly, when the pandemic started, we started to think of ways to file individual motions. So we had to figure out what were people around the country doing, that is other public defenders, and we were doing it like piecemeal, and in many ways it wasn't going fast enough. So we started also reaching out. What were other people doing? Some of them, public defenders, were writing. For example, in San Francisco, they started writing the police, and knowing that that had a lot to do with the numbers of people that were going to be, the numbers of people incarcerated. So if you could control that, you can control obviously the populations and protect people who are incarcerated. What James did, my boss, James Tobby, did is following up upon what other jurisdictions were doing, like in New Jersey, he wrote a letter to the Chief Justice saying, Chief Justice, I would like you to consider among his requests for people who are on probation and doing time to reduce the time. And he had some requests for particular individuals. And what the Chief Justice did was, instead of just as a letter, the Chief Justice took it upon themselves. The Supreme Court treated as a writ of mandamus. So that's the first writ. It was just started with writing. So from then, it evolved so that such that we wanted to expand the people that may be impacted. We were trying to be reserved in the beginning because we wanted to pick probationers, for example, misdemeanants, because those are probably areas where people can find agreement, and there is a finding by a court that the person is not dangerous and shouldn't be locked up. So we wanted to look for target specific groups, but we also wanted to be more expansive, such as the pretrial individuals. And also we brought into the paroling authority and to a second writ, a writ that was filed by our office. That then eventually resulted in the Supreme Court ordering lists of individuals targeting particular groups involving those who were nonviolent, excluding particular charges like sex assault, burglary, abuse of household member, and again focusing on probationers and sentenced misdemeanors with 18 months or less that are misdemeanors. So with that list, though, the Supreme Court didn't just all of a sudden release people. Sorry, but my internet may be a little bit unstable, but
You're
we're gonna
good.
keep on going. Yeah. So instead of just releasing them en masse, the determinations had to be done one by one, an individualized process. So we had to file a lot of motions. I don't know exactly how much, but in the hundreds of motions that we filed, and the judge had to judge it. The judges had to make a decision on what was in that decision making. The prosecutor had a chance to present a response. They could present number of arrests, or what they could object. or at sometimes, once in a while, he would agree. So the judge would then make a determination. And the process was sped up in the sense because it was by non-hearing for the most part. It's because of COVID, you know, the things had to be shut down and decisions had to be made quickly. And whether or not was, you know, we sacrificed a chance to fully respond to uh, uh, what I wanted to highlight at this point, though, in the process was in one of the Supreme Court's orders, something that was really important that I think, and it sort of relates to pretrial bail, is that in the Supreme Court order on April 15th, the Supreme Court ordered that with respect to these individuals that were fit and that were in this category, it says a release shall be presumed unless the court finds that the release of the inmate would pose a significant risk to the safety of the inmate or the public. So one lesson that we can take from this is that having that presumption was important and critical for people to be released. And unless, and still the balance is, well, if they're danger to themselves or the public, then the judge would have to make a finding, would have to go through that analysis and say, no, I know I got presumption, but I have these reasons why. In pretrial bail, one of the things, the measures that should be revisited again and was not quite embraced or passed was the presumption of release. And jurisdictions like New Jersey, for example, New Mexico, California, places like that, we should see what kind of studies, what kind of success they had in terms of you know, those type of pretrial bail systems, because it's shown that from what I know, and then smarter people would correct me, of course, of looking at the statistics, but things like that can be shown to be successful. And I think we need to revisit the presumptions once again when you look at pretrial bail. And what we've learned is that, you know, just a few takeaways is that not only can the presumptions work, but number two, release of these individuals, the defendants, really did not place, our perception is that a release of these defendants did not place the community in greater risk. At some point I read that the arrest rate was around 8%, far less than that was sort of like expected or anticipated for people who may have that figure a little bit higher. So that a study perhaps of what happened in terms of during these releases, how many people got arrested, and you know, a valid study perhaps will be helpful, I think. But from what anecdotal evidence that we had is that we didn't see rampant crime. There was really no spark in violent crime that we saw. We did see an increase in the violation of executive orders, which were mostly non-arrests. And we did see some spike in sibling to sibling altercation, so to speak, because I guess people were, I don't know, people were only at home. So other than that, we didn't really see it from a public defender standpoint. All of that, we concerned that the prosecutors were saying in the media in particular really didn't have any merit. That was our perspective. I know the prosecutors would bring up this particular individual or that particular individual, but they were not part of the writ. They were not part of the COVID release motions. There were maybe individual motions that were filed by the lawyer at the request of a defendant, which we must file, and had nothing to do with this mass motions that we were doing. And I understand that there was one particular one where there was a misdemeanor person that got charged with a very serious crime, but when the person appeared in front of the court for misdemeanor, it wasn't a COVID motion, and a misdemeanor client would have just been released anyway. So, so a lot of these concerns or the worries that all of these horrible things are going to happen did not happen. So that was one takeaway. Another takeaway, and the other takeaway was the reduction of inmate population can be achieved without and because of that, the reduction of the inmate population can be achieved without significant risk to the public. So design capacity appears to be achievable without risk to the community. So while we didn't get all the way down to design capacity, many situations got close, and Kauai, of course, proved that they could do it without any major problems that we know of. The other takeaway that I can say right now, from a public defender standpoint, is targeting specific defendants, probationers, non-violent, non-offenders, those kinds of offenders. Those are the kind of individuals that can be allowed back into the community and presented a lower risk, and may comprise a chunk of the people in detention. Another point that we came away with while we're going through all of this is, people a lot of times people don't have a place to stay, and just getting a address was a little bit difficult for us as public defenders sometimes. A lot of our clients are homeless, but harmless. So this process again has highlighted the fact that part of our system has to address many things, like the residents of our people. How are they going to eat? How are they going to support themselves? How are they going to communicate with the court or with their lawyer, with anybody? So programs, new programs that are being developed, like to provide phones to individuals, are important. But going back to having a serious non-incarceration type settings where people can go and get themselves situated, get themselves hooked up with services, and then back to normal type of living. So we need more of that, of course. Not enough mental health and substance abuse help. And we had to have trouble placing people with those things as COVID came up. So those are some of the takeaways that we thought about, and that we can present to you right now. And perhaps statistics from the paroling authority should be gathered and compared with non-COVID statistics in terms of how many people were released during this time, and Was it more or less, and how did that work? So that would be another point of suggestion as we try to also, in the writ, try to involve the paroling authority in terms of release. So those are some of our thoughts.
Thank you, William. Again, another picture of our topic of discussion today. I don't know about all of you on the Zoom right now, but that was a lot of information to kind of process right now, and I think I succeeded in showing you some of the historical issues on bail reform, talking about what Judge Ibarra mentioned in terms of judges and the intake service centers, and just seeing how public defenders was able to just sit down and write some letters and come to agreement on individuals and allow or make releases occur. He made it sound so simple that once everybody was on the same page, things worked. The ideal now is how do we navigate all of that just happened and replicate that in a new normal? How do we do those things? And that's the basis of why we wanted to have this meeting there, just to hear some thoughts. There's no doubt in my mind, there's a lot of information that came through. But intake service centers came up, bail hearings came up, what's happening at the community correctional centers. Is there reviews being done every 3 months to consider the pretrial population? There is no doubt in my mind that today's meeting, we're not going to solve a lot of problems. But there's going to be a lot of things that we have to think about in the week to come, or when this committee gets back, in terms of how we're going to map this, or where are we going to strategically put our due diligence in. The answer is here. There's no doubt the answer is here. We've seen things happen, and we just have to identify them. Now we talk about, on the agenda, there's this whole thing I put down in terms of the bail reform research. And I'm hoping to have some of you comment once we open up. I'm going to move real fast on this because in my mind, I know research has to be done. Something has to be done to show what happened in the pandemic. But I'm also aware of what the judge just said about the judiciary, the attorney generals, the county police, the prosecutor, the public defenders, public safety, all those agencies that collect information, really trying to understand whether or not they're doing that, and are they doing it well? And then how do we collect that information? I'm pretty sure that even though a year ago in Act 179, Kamaili, you talked about it, the Criminal Justice Research Institute that was supposed to be formed under the judiciary, I'm not sure if that's even moved. So a lot of the thought when I thought about research is how do we try to be creative from the commission's level to try and engage in some kind of research project, or do we push the entities that were created to do those research projects and make them accountable for what the law says? So there's a lot of thoughts going in my head right now, but I know research is a key. Whether it comes from the commission or it comes from this research institute is something we have to answer soon. But a lot of information.
Mark, it's Martha. May I make a comment about the research during COVID? I think that requires something different than waiting for this Criminal Justice Institute or even the AG, because it's a very unique time. And so if we were able to get someone to look at this particular time, I put that up first.
Okay. And that would be my I agree with you, Martha. Right now, I just don't see it in my head because I got a lot of information going right now, But, at this time, I love to hear And, you know, and part of the subcommittee, and if you guys were at the last commission meeting, is really to reach out to the community and say, hey, this is what's happening right now. Give us some ideas of where we can go and how we can get some assistance in the meantime. Yeah. So I'll open it up for comments right now for anybody who wants to have some comments on these agenda items that we've had today. Just wave your hand and I'll call on you. Anybody?
Mark, if nobody's saying anything, may I say something?
Sure, Judge, go ahead.
Okay, so, you know, the bottom line, you know, it's no doubt that we all agree that during the pandemic, you know, the prison population, the jail population was reduced, whether it's through court orders or other agencies' involvement or action, such as, you know, when I said this, you need an arrest to get a bail, yes, but I think during the pandemic or the COVID times, the prosecutor and the police were releasing a lot of folks that were arrested but not charged and issuing citations. So they did penal summons or citation would tell the defendant, okay, here's your court date. And if they don't come to court, then a bench warrant can be issued. But that, you know, that being said, and you know, the public defender's takeaway from the situation, as I see it, is basically it can be done. So the question is, hey, here's the interested parties: police, prosecutor, public defender, public safety, courts. What did you folks do during this period that made it happen? And why can't we continue with it?
Yeah.
That's why.
Good point, Judge.
Can I add something to that, Mark?
Yes, Peter, go ahead.
Well, first of all, Kamaili, thanks for a wonderful job of presenting the data, because what Kamaili's data essentially showed was, despite supposedly years of efforts to change laws and to make bail reform happen, none of it really happened until the COVID crisis hit. And then the data show very clearly that, especially at OCCC, there was a major effort, and we heard the details from the public defender's office as to exactly how this happened. But the political and bureaucratic will was there to reduce the population, and so it happened. And what is absent, and what I'm a little worried about, is that we're already seeing in the data that political will is beginning to erode, and that we're going, we're going back to a pattern that has essentially over half the people in our in OCCC, for example, who are pretrial, and that was a concern of the task force. I can speak to having been on the task force, that we could see Bob Merce did a great job with the data. We could see that a vast number of the people who were, especially pretrial detainees, were very, very minor offenders. So I think what we can do with the COVID situation, and what it will take, though, is, you know, research doesn't just happen. You have to pay for it. You have to get bright graduate students to comb through data that may exist, as Mark has pointed out, in a number of different locations. Even that short period of time, you want to document what happened to those cases. That's going to require hiring a graduate student or two. It's going to require having a principal investigator, at least if you want the university involved. It's going to require, you know, some focus and some money. You can also hire a consultant to do the same kind of thing. Right now, you don't have the research capacity. You don't have this entity that was supposed to be able, from within the, you know, the justice institutions, to do the research. So you have to fall back on other possibilities, and especially you want to act quickly. You have to be limber, and so, you know, going back to someone who's already been doing the research, like Kamaili, makes the most sense to me, rather than trying to bring in other people, even including myself, who are obviously motivated to help. And would be happy to, add my name to the initiative, but you need someone who really already knows these data sets and can go through them and document, as she pretty much already has, what happened. And again, the political will was clearly not there despite all this rhetoric about bail reform for years. The data show absolutely no change. If anything, things got slightly worse. And then during COVID, suddenly things broke free. Certainly I take the judge's comments about personalities involved, but this is also, and again, it was in Kamali's presentation, there were people in this process who were not committed to reform. And that was evident through the process. I mean, all the community people disappeared, the advocates disappeared, and what you had was a kind of inside group who nominally said they believed in reform, but didn't really, and then did no follow-up to do the education that the judge has so correctly noted. But not only education, the political will in the various parts of the system has to be there. And it has been there in other states. And it simply, for whatever reason, Hawaii has a hard time generating the kind of change that we've seen in other states. And however we need to do this, that's the job that lies ahead. We actually have pretty good data from Kamali. So we know kind of what happened. And what we also have to infer is that prior to the emergency, people were just doing what they were always doing, no matter what the rhetoric of change was. So I'll stop there.
I'd like to add something.
Go ahead, Kat.
COVID really showed us what can be done, and it can be done safely. And to Mita's comment on political will, we don't have any political will at the legislature. They tried from the very beginning to stop any releases, and the House released a really scathing letter about not letting these horrible people out without even knowing who the people were, who most of them were pretrial. So we know that this can be done. It's being done in other places. California is going to release another 8,000 people. We're not even through the first phase of the pandemic. So I expect something else to happen. Our numbers are going up and we don't test in our facilities. We have guys who are in Arizona who were with Nevada people and who tested positive, and they were refused tests. We have people in FDC. Finally, the Bureau of Prisons came out and admitted that it's in FDC. Well, gee, people are dying in BOP prisons all around the country. We need to actually provide the community standard of care, and we're not doing that. So COVID showed us that we have all these people who are incarcerated who could be in the community and be provided services at a cheaper rate and more effective outcomes.
I say something also about the process of release. I just want to note too that it was an amazing collaborative joint effort among everyone, and it really was a huge success when you look back at it. And I just want to clarify, because when you look at the releases, that the people who were released from the Supreme Court's order, there's not actually been one case brought to my attention from those releases where it was a reoffense. When the prosecutors were using the media to scare people, they were citing to individual motions filed by defense attorneys, which is what, we file these motions all the time. Anytime someone's arrested, we can file a motion for release, and they were convoluting it. And because of that, the media took it, and it just, everyone just, the leaders, everyone, and there wasn't I guess there wasn't like clear information being given to the media, or they just didn't want to hear it, but it was actually a huge success. And when you look, and I hope there's statistics, people taking into account the orders, the releases that were under the Supreme Court's orders, and looking at that, because again, I was given names from the media and the prosecutors, and they had nothing to do with the releases under the Supreme Court's order.
Thank you, Jackie. Anybody else have anything they want to say?
Mark, this is Bob. I would really like, I've discussed this idea of collecting some data with Mita. And, Mita is the immediate past president of the American Criminology Association. She knows how to do this research. She knows how to structure it. And she knows more than I think anybody in the state about how you collect this kind of data and analyze it and use it effectively. And I just hope, however this is done, it has to be close cooperation, I know, with the Office of the Public Defender, because you need to track certain individuals and what really happened to them. But I hope there's a place for Mita. I hate to volunteer her time on this, and she's newly retired, but I've worked with her, and I know she's got an interest and a passion for making sure that we get some hard data on this, and I hope she can play a role in however this goes forward, because I would trust the work that she did that would be done with the greatest integrity, and I think that's really, really, really important.
I'd like to volunteer Bob Merce to do it with me. That would be
Wow,
my.
learn how to make good charts during the task force.
Yeah.
Mark, can I add one more thing?
Sure.
I think it's really important that if we're choosing to bite off kind of the front end piece of this, that we really always keep in mind that the policing and the arrest is like one of the biggest pieces of this. And so the criminal justice system, especially the triple Cs, don't operate in a vacuum. Like PSD is not in full control over who is in their facilities. And so the great success that we're talking about of this collaboration to reduce the pretrial population occurred in a universe against a backdrop of a full scale reduction in policing during that time. And without that, I don't know if we can ever even fathom recreating something like that, even with the best of with the best of cooperation from all those people who were cooperating the first time on the pretrial release side of things, because the pre-arrest or like the actual policing and arrest side of things is like what is a direct lever that like controls that as well. So I know that you guys don't have jurisdiction and authority or oversight over the police specifically, and it's a little bit more diffuse because they're all county based, but it's absolutely got to be like a huge part of the kind of strategy, addressing that in cooperation with the recognition that you're never going to see the type of results that we saw again without a very concerted effort on the side of policing and arrests.
One other thing I want to say is that it was clear too that what needs to happen is more of like a central point. I was working with Kamali on this, and it was difficult because a lot of the people who were violating due to lack of transportation or actually a phone call during COVID, a lot was just by phone communication. And so if someone didn't have a phone, that was a violation, and they were rearrested. And there actually was a personal donor who donated through the Hawaii Health Harm Reduction $35,000 to get cell phones, but there was this disconnect in getting that information to people when released, and it was difficult. Department of Public Safety wasn't viewing that the release encompassed their duties to inform. So I don't know, we need like a stronger central union where all parties can collaborate everyone use it as their job to help people succeed. And simple things just like cell phones, transportation to court will help people get to court and comply with the terms of the release.
I actually have, we're working on something on that internally. And so I would love to talk with you more about that and just like what kind of things like should be considered in that, because we're definitely at OHA looking at a way to connect people inside to outside after that experience with the lack of triage in between. So yeah, I've got some good leads.
So I just had a couple of things, if I could add, that, Mr. Bagasal really had some great suggestions on, areas to get data on. And one of the things he mentioned was that we're not the only state that took these types of measures, and that as far as I could see just from reading the paper, that what different states did were just as successful as we were, and had the same types of results and overcoming the same types of initial objections. And I think it'd be interesting if somebody had maybe somebody already done it on a national level, but just to show, that this is not just a unique thing to Hawaii in terms of the types of outcomes that came out of this, that showed, how pre-trial without having a bail issue and doing the proper procedures and having some type of assessment that these are really effective procedures, and that it's not just us, that it happens in multiple sites, multiple states. The other thing is that I also heard from Mr. Bagasal and from others, from Jackie, that there are a lot of lessons learned, and it would be really nice to put that together as part of a report. So you have a report on our local data, you have a report on a national level, as well as what was done that really actually was helpful, what worked. And this COVID is going to be with us, and it's good to start to develop more systematically the protocols. That's what's needed. If it's cell phones, if it's food, if it's follow-up housing, making sure that they have a place to stay if they're going to be released, that, we have some kind of a protocol or manual developed that we couldn't start to follow. And that would be really our presentation to the Chief Justice, for one thing, to just say, look, it was a great order that you released, and these were the results that we were able to achieve because of your order. This is what's happening nationally. These are our lessons learned, and put that out there. The only story that we know, that I guess me as a community member heard, was what happened at the beginning, all the objections. But now we have the whole story, or at least a big part of the story, that really the outcomes are much different from what people were saying would happen. And I think it's important to really put that story out there. And Kamali made some great graphs, and infographics is a really good way for people to see what the story is about, based on the facts and the data.
I just included a link to an ACLU report that just came out about crime during COVID. And basically they found the same thing that we did, that crime did not spike. So the link is there in the chat.
Anyone else? It's almost 5, so this is going to be the first time that the commission went 2 hours. So I'm glad that we all remained and was focused on the task. This is our first opportunity to come out as a subcommittee to look at a particular subject. Yeah. So we're learning what we can do as a commission in terms of the Sunshine Law. I'm probably going to ask Lisa to look at, what does a working group look like, and how if that can be put together in terms of bail, just so that we can have a lot of more discussions and just continue to aid the commission in making the right decisions on what needs to be done. I do know that in everything that was said today, particularly about Act 179. If you ever look at Act 179, you know, the majority of it has to do with what Kamaili just talked about. They just took all the recommendations from those former task force and they put it in there. And so in there is a lot of answers I know that the commission, you know, needs to go through. And then, you know, in my mind is a letter campaign to some of these agencies and just ask the questions, what's going on? Based on Act 179, this is our authority and we're asking you, what's going on? Yeah, that's a step one. Step two is really, as a commission, is trying to figure out how we can start something right off the bat in terms of a research project. Yeah, I know I put feelers out there and just asked questions about how we would do a research project, but really is how do we try and meet a you straight on the point. It takes money. Yeah, and right now we're trying to get control of some of the money that we still have, and hopefully if you know, with discussions with the commissioners, we'll see if we can access some of that for a research project. We're not sure yet, but we'll see. Yeah, but that's two things that I see right now coming out of this meeting is that we want to attack and we want to look at, and because of the conversation, that gives us a direction so that we can specifically come back and answer a lot of the questions that was asked here. There's no doubt in my mind that we need to educate the public on what really happened. Yeah, and put a lot of our legislatures to shame for having to say what they said without being accurate about what was going on. So that's kind of where I'm at right now. Judge Ibarra, you have anything you want to say?
No, thank you very much to those that are in attendance too.
This is a great discussion on this bail reform. We're probably going to have another subcommittee meeting. We're going to look at this and try and pinpoint where we need to focus on. And just want to thank all of you to be here on this afternoon meeting. Mahalo. Yeah. Mahalo, William.
Thank you.
Mahalo.
Yeah.
Be well, everybody.
Thank you.
Aloha.
Thank you.
Congratulations,
See you guys
Kamaili.
again.
Thank you.